Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're going to talk about a case that just came down from the appellate division, and it talked about a car crash, a really serious car crash with major injuries, a fusion surgery as well as a knee surgery, an arthroscopic surgery. And I'm going to hold off until the end to tell you how much this particular injury victim received. If it was a lot, like millions and millions of dollars, or if it was a reasonable amount, or if it was nothing at all. Which one was it? So you have to watch the video to find out. But this was a really interesting case, and I learned about it from a blog that I subscribe to that's known as the New York Injury Cases blog, the New York Injury Cases blog. And it's written by another attorney, somebody named John Hochfelder. And I think this particular attorney, it's very interesting. What he does is he compiles a lot of cases. He reads a lot of the appellate division decisions, and he compiles a lot of cases, and then he writes blog articles for other attorneys. And then what that ultimately does is it tells you what something is worth, right? That's one of the number one questions that you, our viewers, ask us. What is something worth? And that's what he's trying to answer. So I give kudos and I give props to John. He's a really good attorney, and he spends a lot of time doing this, and he actually consults with attorneys. But anyway, let me tell you the story of what happened in this case. So this was a car crash. It was a rear-end car crash. It happened on March 5th of 2015, and it happened on Rockaway Boulevard in Queens. The individual was stopped at a red light when another vehicle, a truck, rear-ended his car. And he was 64 years old at the time. He struck his knee on the dashboard, and he said he was jolted forward and then back, which is common after a car crash. You hear that a lot. The neck snaps back and forth. So he ended up needing a serious injury. He ended up needing a discectomy and fusion at 2 levels in the neck. And he also ended up having arthroscopic knee surgery. So he ended up having the back surgery or the neck surgery 4 months later, right? It happened in March of 2015. So in July, about 4 months later, he had the 2 level. It doesn't say which levels. It was probably like, C5, C6, C6, C7, but it doesn't really matter. But he had a 2-level fusion to his neck. And 3 months after the crash, in June, he had an arthroscopic knee surgery. And so the issue of fault, right, the issue of liability was already decided because this other truck hit him in the rear. He was stopped. So there was no question about fault. And so that was not even an issue. In fact, I believe that the truck, the defendant, took fault. They said, we are at fault. We're going to take 100% responsibility, and we are at fault. So the case proceeded to trial on the issue of damages, only damages, right? And it proceeded to trial in Brooklyn, and it actually went to trial during the COVID pandemic. I believe this was a January 2020 trial. So the issues that the jury had to determine were, number one, what is full and fair compensation for all of these injuries? But before they even got to that, right? Before they even got to that, because when they allow for an amount, they allow for the past, from the date of the incident, March of 2015, up until the date of the trial, which was January 2020. So that's about like almost 5 years, right? 2015 to 2020. And then the future, 2020 for the rest of his life. He's like 64, so you figure he's going to live to, let's say, about 80 on average. So that's another like almost 20 years into the future. So it could be multi-million-dollar case. Now, before they even got to that, they had to answer a question. Did this car crash cause the injuries, right? Because how do we know that the car crash caused the injuries? And that's known as substantial factor. So the jury doesn't have to say that the car crash is the only cause of the injury, but the jury does have to say that the car crash was a substantial factor in bringing about or causing the injuries. And the issue in this case was that this particular individual had a prior crash. And the prior crash that he had was in October of 2008. So it was about 7 years before the 2015 crash, right? And in that crash, he had similar injuries. He claimed neck, He claimed back, and he claimed both shoulders and also both knees. Now, he didn't have any surgery for that particular crash, but he had all this medical care. And, he had MRIs, and the MRIs showed some of the same injuries. So, for example, if here he had a C5, C6 herniation, back then he also had a C5, C6 herniation. Now, what the plaintiff claimed is that he said, well, I had, 7 months of medical treatment, physical therapy. I didn't have any surgery, and I was totally disabled. He was claiming a total disability from that 2008 crash, but he basically said, look, but then I got better, I recovered, and then I lived my life. I treated for about 7 months, let's say, so for more than 5 years, right? More than 5 years after that 2008 crash, I was fine. I was back to living my normal life. And, and then this happened, and this is what really caused or exacerbated or aggravated or made worse my condition, because you take me as you find me. This made it worse, and now I have to have all these procedures, right? So that was the plaintiff's claim, and what happened was the defendant argued it a little bit differently. The defendant called 3 different doctors, right? 3 medical experts. There was one orthopedist, there was a radiologist, and I believe the third one was a neurologist, although I'm not sure. I'd have to read the whole trial transcript. That's like thousands of pages because the blog article didn't have that kind of detail. But they called 3 different experts, okay? And all 3 of them said that the injuries in the 2008 crash were exactly the same. They were identical to the injuries in the crash that happened in 2015, the crash that he's trying to recover money for. So they said it was exactly the same. And then they looked at the films, the MRI films, and they said even the MRI films that he had after the 2008 crash, when you look at them, you'll see like the herniated disc, the disc exploding, the liquid leaking and touching the spinal cord. They put them side by side and they said, look, they're exactly the same. So that was the radiologist for the defense. Now, the plaintiff countered that. The plaintiff had their surgeon testify. They had a pain management doctor testify who could also read MRI films. I don't know if they had a radiologist, but they did have another physical medicine doctor testify. And the one thing I saw quickly by, skimming through the trial transcript, I didn't read the whole thing because it's thousands of pages, but I kind of skimmed through it. The one thing I saw was that some of the plaintiff's doctors are like doctors that, you see a lot. They do a lot of cases. They're kind of like advocates. They're not necessarily independent in the sense that they're treating doctors, but they're the kind of doctors that you kind of see a lot. People hire them a lot. So that's not so good for the plaintiff, right? And I think the defendant actually argued that. The defendant, in their closing argument, said, hey, the plaintiff could have used their treating doctor, right? The doctor that's just giving them medical care. But they didn't do that. They hired almost like an expert. It's almost like a hired gun. Why did the plaintiff need to get this hired gun? Now, the other thing that the defendant did was they questioned the plaintiff at a deposition, and they found out what happened, and they learned that the plaintiff, the 64-year-old, he wasn't alone in the car, but he also had his granddaughter in the car. And his granddaughter, after the crash, she started crying, and she was taken from Queens. The crash happened near John F. Kennedy International Airport. She was taken all the way to Long Island to a hospital. And then the plaintiff, after the crash, the same car that was involved in the crash, he drove to the hospital, and then he waited in the parking lot for her to be discharged. So he waited over an hour. So the defense attorney did it. I guess it's a smart thing. He said, look, if you're really hurt in this crash, you're at a hospital. Why don't you go inside and get some treatment, right? And I don't know what argument the plaintiff had for that. So that was one of the things that the defendant argued. So then before the jury rendered a verdict, the defendant proposed a high-low. So they said, no matter what happens, even if you get nothing, right? Even if the jury says this was not caused by this particular crash and they give you nothing, we'll give you $300,000. So you'll get something, that'll be the low. And the high will be $1.75 million. So you have the high and you have the low. And the plaintiff said no to that. I think he said no to that because he had a lot of liens, either for surgery or for funding that he took, case funding. And so if he did get $300,000, all of that money would go to these liens and he would actually get nothing. So he said no to that, and his attorney agreed with saying no to that. And then in closing arguments, the plaintiff's attorney told the jury that they should allow for $5.5 million, $5.5 million. And the defense attorney said, allow for nothing because it's not caused by this crash, but if you're going to give something, just give like 10,000. And they were really harping on the fact that there wasn't much damage to the plaintiff's vehicle. They're saying, look, the plaintiff was driving an SUV. This is a large truck, but it was just a little tap. If there was a serious damage, then look at all the photographs. And they showed all the photographs right in opening statement. And they said, look, we have nothing to hide. And we just want to be honest with you. Look at all these photographs. And they looked at the photographs and they didn't really show, I didn't see the photographs myself, but according to what I'm reading in the trial transcript, it seems like the photographs didn't show much damage because that's what the defense was really, really harping on. And so let me tell you what happened. So the defense, so then the jury had to answer this question. And the question was this crash a substantial factor in bringing about the plaintiff's injuries? And the jury answered no. They said it was not. So at that point, all the other questions did not have to even be answered, right? If you answered yes to that the crash caused the injuries, now you have to answer, well, is it a serious injury? Is it a significant limitation? And there's other categories of serious injury. If you answered no to that, also you would get nothing. So there's a lot of hurdles, right? There's a lot of steps that the plaintiff has to jump through, that it has to overcome in order to recover anything in a car crash case. But, if they would have answered yes to the first question, then they could have answered yes to the question about serious injury, because it was serious, and then they would have allowed for the amount, right, past and future. But because they said no, that it wasn't even it wasn't even caused by the crash, then they didn't have to answer anything else. And then what the plaintiff did was they were so upset by this, they said, look, how could it be? This is a fusion surgery. This is a major, major surgery. How could it be that we're getting nothing? It's not caused by this. So what they did was they filed an appeal, and the appeal went to the second department, the appellate division, second department, because this was a Brooklyn trial. Like I said, it was during the pandemic. It was actually in front of a judge who's now the jury coordinating part judge in Brooklyn. And when I did my trial in February of 2023, I had to, when I was doing jury selection, this was the judge that would rule on our jury selection challenges for cause, and she was the administrative judge. And then we got assigned to another judge for the actual trial. But this judge actually during COVID, she tried this case. And during January of 2020, this was actually before COVID. January of 2020 was actually before COVID. So yeah, I was there January of 2020. I was trying another case. I was trying a case in the court across the street, in civil court. That was the slip and fall case before another, also a female judge, and that case resulted in a $1.5 million settlement right before the jury verdict. But yeah, so I apologize. This wasn't during COVID. This was right before COVID. But anyway, they said no. So then the appellate division gets the case, right? And the appellate division is looking at this, and they basically said, look, the legal standard in a case like this is we have to look at what is a fair interpretation of all the evidence. And if this conclusion that the injuries are not caused by the crash, if this conclusion can be reached on a reasonable view of all the evidence, then the presumption is that that's what the jury did, right? We have to give, credence to the jury. We have to give the jury the benefit of the doubt. So if it can be reconciled that the jury reached this view based on the evidence that was testified to, the photos, the medical records, the experts, the plaintiff, then that's what we have to do. And they said, look, 3 different doctors testified that this injury was not caused or even made worse. It was not aggravated. It was not exacerbated by this particular accident, right? By this particular crash. So, and then they said the imaging studies are identical. And so for that reason, the appellate division sustained that particular jury verdict. They didn't want to disturb it. And they said that the judgment is affirmed with costs, meaning that the plaintiff has to pay the costs because they filed an appeal, and the judgment is affirmed. So now this particular individual is going to get nothing, unfortunately. So it just happens. Like, I wanted to make this video because, I do a lot of videos and I tell people what usually cases can be worth. And sometimes a case like this, a 2-level fusion, can be worth $1 million. Look, it could be worth more. There have been verdicts for even up to $9 million or more for fusion surgeries. They're serious injuries. But sometimes in a case like this, if the case isn't built the right way, or sometimes, you know, the case is built the right way. This particular plaintiff actually had a really good attorney. It's a very, it's a big firm, and they have a very, very good reputation. So it's not really, I don't think it's the attorney's fault, but what I would say is, you know, you just never know what a jury's going to do. And sometimes when you're in that discovery process, right, when you're building a case, when you're discovering information, sometimes you discover information that's not so good. You know, you don't create the case, right? You discover what it is. So sometimes here, if it really is true that MRI from 2008 was exactly the same as the MRI from after the 2015 crash, then there's not really much you can argue. The whole point is there has to be some kind of change. Now, if in 2008 they had nothing, or if they had a small bulge, but then in 2015, 7 years later, all of a sudden they have a herniation, right, an extrusion where the disc is ruptured and the liquid inside the disc is leaking out. I think the lawyer in this case almost said it's like a tube of toothpaste. If you squeeze the toothpaste, you know, leaks out, or some people say jelly donut, and it leaks out, it touches the nerve roots, that causes pain. But you have to argue that, or you have to prove that that's from the crash, right? If it was a minor impact, if you didn't go to the hospital, if you went to treatment with all these doctors that are always testifying for plaintiffs and aren't necessarily fair because they're advocates, now all of a sudden there are a lot of red flags in the case. And also, you know, I did another video, which you could check out here, and that video talks about pre-existing conditions and how to deal with pre-existing conditions, because it doesn't have to be that the crash created all new injuries. You could have a pre-existing condition, but then you're already vulnerable, right? You're already susceptible. You're more susceptible to harm. And then this particular crash pushes you over the edge. So it's kind of like the straw that broke the camel's back. And now you have more injury because you were more fragile and more vulnerable because you had a prior weakness, right? So if you were, like, let's say at a 5 out of 10 before, well, you're already hurt, right? If you were at a 10 out of 10 or a 9 out of 10, maybe the crash brings you to a 7 or a 6, but you're still okay. But if you were at a 5 before the crash, now the crash brings you down to like a 2 or a 3, now you're really hurt, right? So that's the argument I would make, but it has to be supported by the medical evidence, by the doctors, by the radiologists. What I did in my trial, when I got a $3.5 million settlement in the Bronx, we were very, very similar. The plaintiff also had a prior fusion. And not only did he have a prior here, the plaintiff never had a prior surgery, right? The plaintiff only had a prior, herniation, a prior crash. But in my case, the plaintiff had a prior crash, and he had a prior fusion, an actual surgery. And now he was getting another fusion, but like at one level lower, which is an adjacent disc disease. But what I argued is I actually showed the films, the MRI films, and I didn't just show the MRI films to the jury, but I showed the MRI films and I got them a 3D image of the film. So you could actually see what's happening. Because if you just look at a black and white MRI, it's very hard, even for a lawyer like me, to understand it. A lot of doctors cannot read MRI films. Jurors are not going to be able to understand it necessarily. There's like thousands of different views. There's sagittal, axial, this and that. So what you do is you want to get a 3D rendering, and then it's like a 3D model, and you could actually see the disc like bulging out on a 3D model. It's almost like this. You see it happening, and then the other thing that you could do is you can get a color MRI. So the color MRI will show the spinal pathway, right, the spine, and it'll show the herniation going into the canal, right? Because the canal is where all the nerves run, your spinal cord. That's how you have feeling. You can move your arms, your legs. That's how, that gives you all sensations. And that canal basically is getting pushed by the herniation. And now that canal is not, is basically destroyed. And it's not like a pathway where signals and neurons can run and nerves can run up and down, but the canal is destroyed. And that could lead to like myelopathy, that could lead to paralysis. That's very, very serious. That's one of the most serious things, which is why people get these spinal surgeries, because nobody wants to do a spine surgery. It's a dangerous thing to do. So, okay, so I hope this was helpful. Let us know what you think, but I thought this was an interesting case because usually when you see a fusion surgery, you think, oh, millions of dollars, but it doesn't work so easily. And this is another example why some people write comments and they're like, oh, I had, this and that. How much am I going to get? You see, you can never really know how much you're going to get because If this case was a little bit different, let's say the patient didn't have that prior injury, or maybe if the patient called the radiologist and the radiologist would have shown those color imaging and showed how it was different, or maybe if, he would have gone to the hospital, then it might have been different, right? If the case was built differently, it could have been different. It could have been $1 million result. But this particular case was a 0 result. So it happens too. I don't want to make it seem like it's also easy and that everyone is walking away with millions of dollars. The other thing that the defense lawyer did, and the plaintiff's attorney objected to it, but the judge said, look, it's a fair comment on the evidence, is in closing, the defense attorney said, look, this guy is looking for a payday, because look, he's been a litigant before in 2008, so he knows how the system works, and now he gets into a little minor fender bender, not a scratch on his car, and he goes and he does this because he's looking for a payday. He saw it as an opportunity. And I don't know, I don't know if it's better to object, because it seems like this plaintiff's attorney, he was getting up and he was objecting a lot, because the defense attorney was making a lot of these arguments in opening and in closing. And in opening, I think I counted like 6 or 7 objections. And in closing, there were a handful of objections as well. And what that really shows the jury is that, you don't want this evidence to come out. You're objecting. I mean, some of the stuff may be improper, but the judge will just say, look, okay, don't do that, it's objection sustained. But the fact that you're objecting, the fact that you're jumping up, the fact that it almost shows that you have something to hide, right? And maybe that influenced the jury as well. I'm not sure, but that's just from reading the transcript, it's hard to say. So many factors go into a trial, right? You have to pick a jury. So you speak to the jurors, you select the jury, then you have to give your opening, your closing, the judge's interactions, everything, interplay of witnesses. One witness might turn everybody off and they might say, you know what, I don't believe that witness. They have no credibility, so no, I'm not going to believe anything else this particular party says, whether it's a plaintiff or a defendant. That's possible too, right? There's so many variables. So it's not an exact science. That's why they call it the art of advocacy and trial practice, the practice of law, because you're always practicing, you're always getting better. But I thought this was an interesting case, so I wanted to share it with you. Let us know what you think. Please like and subscribe to our channel. We are here for you. Drop your comments, ask us your questions, and we will do more videos about cases like this and other cases, including cases where there are 7-figure and multi-million-dollar verdicts and settlements as well. Okay, thank you for watching and have a great day. Bye-bye.